It's a new year and a new chance for you to make a fresh start with your compliance. For it, we're going to be bringing you a daily tip, strategy, or idea that you can use to improve your program. Here's your host, Tom Fox, the Compliance Evangelist.
Hello, everyone. This is Tom Fox. For the month of April, we're going to be looking at third parties and your third-party risk management program. In this first episode, I visit with Alexander Cotoia from the Volkov Law Group. He talks to us about key 2022 FCPA enforcement actions around third parties and what they may mean for your compliance program going forward. Today, I'm thrilled to be joined by Alexander Cotoia from the Volkov Law Group. Alexander, first of all, welcome and thank you so much for taking the time to visit with me today.
Tom, it's a pleasure. As I've indicated to you before, I've been a loyal listener for many years, so it's surreal to be here. And now I'm with the Volkov Law Group, where I handle a variety of matters related to third-party due diligence, sanctions, compliance, and export controls.
Alexander, I've been in the anti-corruption compliance space since 2007, and the most clear, consistent fact has been, when it comes to enforcement, third parties. Fully in 2022, 90% of all FCPA enforcement actions, over 90% involved third parties and getting companies into trouble. So I thought I wanted to ask you, what were maybe three of the cases that caught your eye from the past year that involved third parties and what made them unique from your perspective?
Yeah, so Tom, as you alluded to, I think it's really important to emphasize in 2022 an overwhelming majority of FCPA-related enforcement actions that were brought by the DOJ or SEC involved third-party intermediaries. So we're talking about an organization's agents, consultants, contractors, service providers, distributors, the whole gamut, other external parties on which an organization relies operationally. Now, that's in keeping, as you alluded to again, what we already know from a decade plus of collecting FCPA data, that the overwhelming majority of these enforcement actions involve third parties. So I think the 2022 data certainly underscores a need for organizations to reprioritize third-party risk management as a core compliance function. And I think sometimes there's a tendency to become complacent in that arena, but you really can't afford to be complacent, especially as we have a new emerging considerations respecting sanctions and export controls that have become core enforcement priorities of the federal government, as we saw recently with the relatively novel joint compliance note that was issued by the Departments of Justice, Treasury, and Commerce. So I think the first case I wanted to talk to you about today was the case of ABB Limited, which has the dubious distinction of being a repeat FCPA offender. In December of 2022, the DOJ announced a resolution with ABB Limited, which is a Switzerland-based company, but subject to the FCPA by virtue of being an issuer within the meaning of the bribery prohibitions. Now, according to charging documents, between roughly 2014 and 2017, ABB paid a high-ranking official affiliated with a state-owned energy company in South Africa to retain and obtain engineering contracts for the maintenance of a power plant in South Africa. Now, tellingly, it did so by hiring subcontractors that had very close ties to the government official to deliver engineering services, even though none of the subcontractors were qualified to perform any of the work that they were assigned. So the subcontractors in the ABB case were essentially used as a conduit to funnel payments directly to the government official in question. And in exchange for these payments, we know from the information that was unsealed, ABB benefited by receiving preferential treatment from the government official in question, including access to confidential bid information and the payment of grossly inflated invoices. So ABB was ultimately charged criminally by the DOJ and held civilly liable for its misconduct by the SEC. To settle the criminal proceeding, it entered into a DPA and agreed to pay a criminal penalty of approximately $315 million. And a portion of that was offset by the $75 million civil penalty it was obliged to pay to the SEC.
So how about, I know there was a case involving distributors, Oracle, and I was very intrigued that you selected that. So what about the Oracle matter and distributors really caught your eye?
So the thing that really caught my eye with respect to the Oracle case, and again, we're talking about another repeat violator because I believe they were charged in an administrative proceeding by the SEC in 2012 for substantially identical conduct. And here they were using a scheme involving indirect resellers to pass along improper benefits to government officials. And the essence of the scheme, it's a little bit complicated, but the essence of the overall scheme involved complicity on the part of Oracle employees who authorized excess discounts to value-added distributors and resellers. And those discounts were in excess of what Oracle policy mandated. So then these discounts were pooled collectively and then used as a slush fund to provide travel and entertainment to foreign officials. And in some cases, the indictment alludes to direct payments to those officials. So under a no-emission settlement with the SEC, Oracle agreed to pay a total of $23 million, of which $15 million consisted of a civil penalty and $7.9 million consisted of disgorgement and prejudgment interest. But what's so notable about the case, again, is that Oracle was chided by the SEC in 2012 for substantially similar conduct.
And then your third case, I believe you told me, was GOL Airlines. What caught your eye on that?
Yeah, so that was a really interesting one. GOL Airlines is, of course, a popular low-cost carrier operating in Brazil. Although it was based overseas, like ABB, it's subject to the FCPA's anti-bribery prohibitions as a domestic issuer. Also, like ABB, GOL Airlines was the subject of both a criminal proceeding initiated by the DOJ and an administrative proceeding initiated by the SEC. So according to documents filed in that case, a member of GOL board of directors actually agreed to pay high-ranking Brazilian officials approximately $3.8 million in bribes to secure favorable legislation that reduced payroll and aviation fuel taxes that were specific to the airline industry. Now, these bribes were paid to a third-party intermediary under the guise of sham contracts with a number of consulting companies that were controlled by the intermediary in question. So the intermediary would then pass on a substantial portion of the payments he received to the government officials in question. And for its misdeeds, GOL was fined about $87 million, but that amount was largely predicated on the receipt of maximum cooperation and remediation credit that the government explicitly acknowledged but because GOL was not able to pay even that amount, the fine was ultimately reduced to $17 million. In the SEC proceeding, GOL was ordered to pay $70 million in disgorgement and prejudgment interest, but that was ultimately waived. So they only had to pay about $24.5 million over the next 2 years based on their precarious financial condition.
Alexander, I'd like to now actually circle back with a term you started with, and I thought it was brilliant: reprioritize your third-party risk management program. And here we are in 2023 saying reprioritize your third-party program. It's never gone away, but it's just as important today as when I started in 2007. So I wanted to maybe pivot a little bit, but looking at the business justification you might need, the questionnaire you would send out, and the due diligence that you would receive based upon the questionnaire, how you would evaluate that due diligence, and then after the contract is signed, how do you manage the relationship? Is that a process you help a client think through or put in place, or what sort of process might you suggest around a third-party risk management strategy?
Yeah, so Tom, I think looking holistically at the three enforcement actions that we just highlighted, I had three critical takeaways that kind of allude to what you just mentioned, which is reprioritizing risk management. And the first principle is you have to understand that third-party risk, especially as it pertains to anti-bribery and corruption concerns, is a universal constant. In other words, while the form of bribery and corruption schemes tends to morph over time, the essence of the underlying quid pro quo misconduct is the same. So anything that's really designed to improperly influence foreign government officials in their official capacity needs to be heavily scrutinized to see if it rises to the level of an FCPA violation. Second, look, voluntary disclosures and substantial cooperation work. Look no further than the Oracle case, where the government noted Oracle's cooperation and remediation efforts in the context of the SEC's cease and desist order, and this despite the fact that it had been charged with a very similar misconduct in the past. So avoid the temptation, which I know is very potent in legal circles, to obfuscate and deny when confronted with a potential FCPA violation. I think, as the Deputy Assistant Attorney General has repeatedly emphasized over the course of the last few years, full cooperation credit is contingent on disclosure of all material, non-privileged facts and information. So don't put yourself in a position of being uncooperative with either the SEC or DOJ. And finally, I think in this environment, you need to reassess the framework by which third parties are evaluated. We commonly refer to this in compliance circles as due diligence. I would encourage your listeners to revisit their frameworks for third-party risk management holistically and really hone in on the nature and quality of the information that's being collected. The critical question to ask from a functional perspective: is it adequate to objectively evaluate the totality of risks posed by a potential business partner to the organization? So many times, organizations, I think, adopt a one-size-fits-all approach to TPRM that is ineffective and not in keeping with DOJ guidance, by the way, which requires companies to adopt a risk-based approach. So really take this opportunity to gauge the effectiveness of your current TPRM practices.
Alexander, unfortunately, we are near the end of our time for this episode. But before we leave, I wanted to ask you if our listeners wanted any more information on yourself, your practice, what would be the best place or places for them to go?
Yeah, the best place to go would be www.volkovlaw.com, or you can send me an email at Cotoia, ACOTOIA, at volkovlaw.com. And we're very responsive to our clients and very happy to get new.
Alexander, I wanted to thank you again for taking the time to visit with me today. This was a great way for us to button up this podcast series, and I look forward to continuing this conversation.
Tom, it's always a pleasure. Thank you very much.
This is Tom Fox again. Thank you for listening to this episode of 31 Days to a More Effective Compliance Program. I hope you will join me for the entire month where I take a look at some of the significant changes in compliance and FCPA enforcement. 31 Days to a More Effective Compliance Program is a part of the Compliance Podcast Network. If you'd like information on any of the topics from this podcast series, please check out the Compliance Handbook 3rd edition, available at lexisnexis.com/Fox.